The sofa dropped on one side in month 6, not dramatically, gradually over about 3 weeks, until one end was visibly lower than the other, and sitting on it felt different depending on which cushion you chose. I called the retailer. Their technician visited, assessed, photographed, and produced a report I was not shown. The outcome was communicated to me by phone. The fault had been assessed as resulting from normal wear and use, rather than a manufacturing defect. It fell outside the company's warranty and returns policy. I asked for a copy of the technician's report. They said it was an internal document. I submitted a subject access request. Under UK GDPR, I was entitled to a copy of personal data held about me, and a technician's report assessing damage to goods I had purchased, containing my name, my address, and details of my claim, is personal data that describes me and my situation. I requested it. The report arrived within the statutory period. I read it carefully. It described the frame deformation as consistent with structural fatigue. It did not identify any specific misuse on my part. It noted that the sofa was a lighter specification frame than the product tier above it in the same range. Structural fatigue in a sofa frame at 6 months of normal domestic use is a manufacturing defect. I opened the Consumer Rights Act 2015. The Act is specific about goods that develop faults within the first 6 months of purchase. In that period, the fault is presumed to have been present at the time of sale, unless the retailer can prove otherwise. The burden of proof is on them, not on me. Their technician's report had not discharged that burden. It had described structural fatigue without identifying any cause that could be attributed to my use. It had noted a lighter frame specification than the tier above. Neither of those things came close to proving the fault had not been present at the time of sale. I paid £60 for an independent upholstery assessor to review the technician's report and provide a written opinion. He confirmed that structural fatigue at 6 months indicated a frame specification that was inadequate for normal domestic use. Exactly what the Consumer Rights Act's implied term of fitness for purpose is designed to cover. I wrote to the retailer. I cited the Act. I explained the reversal of burden of proof. I attached the independent assessment. I said I was entitled to a replacement, or if the replacement could not be made satisfactory, a refund. They offered a replacement. The replacement was delivered. Before the delivery team left, I had the frame assessed informally by the same independent assessor I had consulted previously. The specification was identical to the original. I declined the replacement on the basis that the same defect was reasonably likely to recur. I requested a full refund. The retailer initially resisted. I wrote again, formally, noting that the replacement remedy had failed, not because a fault had occurred in the replacement, but because the replacement was of the same specification, and the defect in the original had been established as relating to that specification. In those circumstances, I was entitled to a refund. They agreed within a week, £1,420. The retailer's policy was not the law. The law is the law. Has a retailer ever tried to apply their own policy instead of your legal rights? Drop it in the comments. And if you want more complete stories with no part 2s that never come, follow the page. New story every day.